Sure, yeah, it becomes very important both at the due diligence level as well as in structuring the transaction. For the most part, it's quite difficult to have access to a lot of information in the due diligence process when you're dealing with a local target. If the target has obviously a sophisticated set of management folks, as well as maybe potential joint venture partners that have infiltrated the culture of the target, that doesn't necessarily pose too much of a problem. However, in most companies, it's a very difficult aspect to ascertain in the first instance. So in the due diligence process, it becomes something that we always request and push on, but the reality is you have to work around. You almost have to assume that you're not going to get as much information as anyone would on most transactions in, say, Europe or the U.S. So it comes up in the due diligence phase, as well as it comes up when you're structuring a transaction, when you're targeting a company with the idea of potentially expanding out into the region or expanding out into other areas. You need to also figure out exactly what other tying arrangements, what other joint ventures, what other partners they have, because that will definitely dictate in terms of how you can expand and potentially navigate through those waters. And that level of information gathering doesn't necessarily come from the target. Most times it comes from outside advisors, because again, maybe a family conglomerate might have a sister company that doesn't necessarily report up to the same figure in terms of the company, and you can't get access to that unless you, again, do it on a separate basis. So that kind of information gathering is absolutely critical to both the due diligence process as well as going forward. Yeah, sure. I mean, a lot of it, clients come to us not only to give them sort of the legal advice, obviously, in terms of structuring the deal, but also to give them as much on the due diligence side. So what we do is we certainly look out for the sector that's specific to the target, and we try to sort of almost map it out for the client to say, you know, your target and the principal that you're going to be joint venturing with has this type of landscape with regards to the sector. Here are the other players as well. Here's what we think. There's either a connection or no connection between those other players. And again, that becomes quite difficult when you sort of, it depends off how far out you throw that web. I mean, if it's really just the GCC, the UAE, Saudi Arabia, and certain other GCC countries that have quite a sophisticated M&A market, that's easier to do. When you start getting out into the Levant area and so on, it becomes quite more difficult. But that's certainly something that our clients would ask us to work around. And also when you structure the deal and the documents and the kind of risk analysis that you put into the actual M&A transaction itself, we have to work around with the assumption that we don't have full information on certain aspects. So not only do we do the due diligence up front, but we also try to backstop as much of that gap as possible in the documentation. Yeah, sure. I mean, for those who have never done a deal in the UAE or the GCC as a whole, Saudi Arabia is the exception, actually, is that you're always going to have this 51% local ownership rule or the 49% foreign ownership restriction, what basically means when you go to seek a target that's onshore, for the most part, you're going to have to be relegated down to a minority interest, 49%. Bahrain is certainly more open. Dubai has free zones, so if your target is in a free zone, clearly you can own 100%. Saudi Arabia is actually the least restrictive from an onshore basis in terms of the GCC. You're allowed to own up to 100%. There's a negative list that brings it down to about 75, so long as you put in a certain level of investment. So you can actually own up to 75% in a lot of cases. So, getting through that kind of structuring issue in the first instance is certainly important. And the difference is, that same rule has been in place for the last 20, 30 years in most of these jurisdictions. There has been this concept of a nominee arrangement. So if I'm the local, I agree to, in a sense, give you my shares, even though legally I'm entitled to those shares, and I enter into certain nominee arrangements with you. The problem with that is that there's anti-fronting laws that have come up, certainly in Qatar, here in the UAE, even though there's some dispute as to whether or not it's legally enforced or not. Nevertheless, it has always been sort of in the books. Very difficult to stay below the statutory line or regulatory line if you enter into these types of nominee arrangements. And so we try to structure the deal without using nominee arrangements. And there's other sort of clever ways of certainly doing that that have been tested. And every jurisdiction has a little bit of a different subtlety towards what level of of alternative arrangements you can enter into.